All rise and give your attention to the Honorable Justices of the Montana Supreme Court. This court is now in session.
I'm in the wrong place. Just give me a moment. I will note for the record that we have the first team from the clerk of the court's office. The Honorable Darlene Gallagher is present today. This is time for the oral argument in DA 18-0006. Good morning to everybody. Good morning. Are counsel ready to proceed?
Yes, Your Honor. State as Your Honor.
Mr. Mercier.
I'm told it's the wind.
Oh, thank you.
Good morning. My name is Cohen Mercer. I represent TREVOR MERCIER. A physical face-to-face confrontation at trial. In Maryland v. Craig, the United States Supreme Court reaffirmed that the Confrontation Clause includes the right to, quote, a physical face-to-face confrontation at trial. And the court in Craig guaranteed that this right could be abridged, quote, only where denial of such confrontation is necessary to further an important public policy. Neither the state nor the district court here make any claim that denying physical face-to-face confrontation here was necessary under Craig. It was not. Special Agent John Drude was a paid government employee. He's an officer of the Department of Homeland Security whose very job it is to testify at trials. He was an expert witness to whom the state had chosen to submit evidence for evaluation. The state had bought the plane ticket, made the travel arrangements. As the prosecutor put it below, the state was, quote, fully prepared to get Mr. John Drude here. The state described the use of video testimony below as an issue of, quote, judicial and, quote, practical economy. But economy and convenience are not necessity. As the Ninth Circuit recently held when reversing the use of two-way video in testimony in Carter, a criminal defendant's constitutional rights cannot be neglected merely to avoid added expense or inconvenience. I hope this morning to talk about three things. First, the importance of face-to-face confrontation. Second, the state's proposed asserted exception for foundational witnesses. And finally, City of Missoula versus Duane. So first, the right for in-person confrontation exists. It is enshrined in both the Sixth Amendment and Article 2, Section 24 of the Montana Constitution. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. The United States Supreme Court has interpreted this clause to confer, quote, at least the right to meet face-to-face all those who appear and give evidence at trial. In Craig, the United States Supreme Court held that this right, like many rights, is not absolute. But in doing so, the court simultaneously and explicitly cautioned, quote, that the face-to-face confrontation requirement is not absolute. It does not, of course, mean that it may be easily dispensed with. The court continued that face-to-face may be abridged only when there is a case-specific finding of necessity. Following Craig in 2002, the United States Supreme Court rejected proposed changes to the Federal Rules of Criminal Procedure that would have allowed the use of two-way video testimony. In doing so, Justice Scalia highlighted that testimony in a defendant's presence is not equivalent to testimony, quote, in a room that contains a television set beaming electrons that portray the defendant's image. The Montana Constitution is even more direct. In all criminal prosecutions, the accused shall have the right to meet the witnesses against him face-to-face. This court in Stock recognized that the elements of confrontation include physical presence. In Stock, this court upheld Montana's two-way video statute for child witnesses, quote, because it requires an adequate showing of necessity. Face-to-face confrontation is important both because of its intangible effects on human communication and because of its symbolic value in legitimating the actions of our criminal justice system.
Counsel, can I ask you a question about Stock? That was a statutory scheme that the court applied. Here we don't have that same statutory scheme. Is that of any significance?
So it was the Montana had adopted, after Craig, a two-way child video statute scheme, and there was a constitutional challenge that that scheme was unconstitutional. The court held that it was not. Some courts have raised an argument that when you're looking at what is an important public interest, that needs to be said by the legislature. And so having the legislature say that child witnesses and avoiding re-traumatization is an important public policy matters. Other courts have not, but we have not raised it, but it is interesting to note that the same way in 2002, the U.S. Supreme Court rejected the Federal Rule of Criminal Procedure that would have been a general statute allowing two-way video. There is no general statute in Montana allowing two-way video testimony. It does not exist. The only statutes that allow video testimony are for child witnesses or preliminary things where the Confrontation Clause doesn't apply. The importance to communication, human communication, of face-to-face confrontation. For millennia of genetic and cultural development, humans have interacted with each other face-to-face in person. It is our method of maximal communication. We receive...
Well, counsel, to that point though, and this argument's kind of illustrative of that, times have changed. I mean, a lot of face-to-face communication is being done via electronically. I mean, over half of the court here right now is on my computer screen.
Right.
So isn't there something to be said when you're talking about face-to-face communication that it can be done electronically?
So first, just for the point here, to be clear, confrontation doesn't apply here, right? We don't have a right to personal presence here. This is not a trial. The broader question, technology has changed, but that's not really the question. The question is, have we changed? Are we different? So it's convenient, and we have now downloadable high-fidelity music, but we still go to live concerts. We have screens that provide resolution greater than the human eye can tell, but we still go to live theater. We can Skype with our parents every night, but in these COVID times, we still yearn to sit across the kitchen table from them for a few minutes because it's different. It will always be different. If at some point we as a species changed where virtual reality is the same to us as in person, then we can amend the Constitution. But until we do, the Constitution unambiguously provides for physical, face-to-face confrontation and trial.
Where's the word physical? It says face-to-face. Where's the word physical?
That's the court's word in Craig. The United States Supreme Court. Remember, Craig, 4 votes say there is an absolute ban. You can never do this. 5 votes say there is a very narrow exception, but 9 votes say the right exists to in-person confrontation at trial.
Okay, but for our purposes, and I understand that what it says in Craig, but for our purposes, the words physical, when we're talking about constitutional interpretation, do not appear in either Article 2, Section 24, or in the 6th Amendment. It just says face-to-face. In documents that were written before the advent of this technology.
I think this is important because that's not true about the 72 Constitution. As part of recent presidential fiascos, right, that caused me to learn that in 1960, President Kennedy and Richard Nixon debated by live two-way closed-circuit television, 12 years before our framers said face-to-face.
But it certainly wasn't as ubiquitous as it is now, and
Right.
and as it's become even more so over the last several months.
That's true, but it's still... I find difficulty reading face-to-face to mean anything other than in person. That's what it had always meant. We look at our statutes provide for, when the two-way child video statute provides for two-way video versus in-person.
But a lot of things have changed because of technology. I mean, Fourth Amendment issues have changed. When the Constitution was originally drafted, nobody contemplated infrared screening and flyovers or drones or anything like that.
I think the infrared screening, though, is a great example, because then what does the U.S. Supreme Court say? They say, well, yeah, we didn't know about this technology back in 18 whatever, but does it allow us to do something that we couldn't do under before? Look into someone's house. So you need a warrant.
But there's also a recognition that when you're talking about the advent of, or the advances of technology as it pertains to Fourth Amendment rights, there's a recognition that the reasonable expectation of privacy has been somewhat fluid, and the cases recognize that. I mean, somebody who might have otherwise had a reasonable expectation of privacy in 1789 might not have the same expectation of privacy if they're in, there's the cases that recognize if you're in a flyover zone, that you might not have the same level of expectation of privacy. And that's because of the technology that didn't exist when the Constitution was originally drafted.
And yet on the other side, you do have the infrared case where no one would expect someone to be able to look through their walls. Now we can, we would expect an infrared camera can look through my walls, but the Constitution cuts it off because the home is still the home. We have the cell phone cases. Yeah, we still have to get a warrant. I think the argument too that if it wasn't envisioned, that means it's allowed. The text doesn't allow it. If we want to change, if we want to make video confrontation allowable, then we need to amend the Constitution. We can fully do that. But until we do, the U.S. Supreme Court has always unambiguously interpreted it to be in-present confrontation. Because that in-person is part of the, so remember too that this right is personal to the defendant.
Counsel, let me ask you a question about that. It seems to me that the common thread in all these federal and state cases, that the essential touchstone of the constitutional right to confrontation is the opportunity for meaningful and effective defense cross-examination of adverse witnesses inside of the jury to thereby afford the jury full and fair opportunity to assess the veracity and credibility of the witnesses. And I guess in the context of this case, I don't see that you've articulated any compelling justification or explanation as to how modern virtual confrontation is any less meaningful for those purposes than physical presence in the courtroom. Can you address that?
So, Your Honor, I guess I disagree a little bit with the first premise. I think the cases make clear, going back to Maddox, that there are multiple parts of confrontation. There are different elements. One element is cross-examination. One is being in the jury's presence, being able to be seen by the jury. But another element is the physical presence of the defendant and the witness in the same place.
That's my point. What is the point of that as it relates to these rights of the physical presence? Why in your view, do we have those constitutional requirements?
So because there's two things to me. One is that the intangible effects of being in the presence of someone are real. They're unpredictable. We can never know pre-trial how the effects of being in a witness's presence will affect the witness's testimony or how the trial plays out, but that doesn't make it any less real that it's unpredictable.
How does it make it any less real if it's virtual as opposed to live in the courtroom?
Because I can't feel your eyes upon me. I can't make eye contact with pixels on a screen. We say things like the eyes are the windows to the soul, but a few dark pixels on a screen are not. We are not physically in the space. So the millennia of our development as humans have taught us, have cultured us, have bred us to interact with people face to face in the real world. And the right is personal to the defendant.
Counsel, we're interacting right now very directly. I can see directly into your face. You probably, unfortunately, can see too much directly into my face. I don't understand how this does not afford the essential essence of the state and federal right.
And so the other part is the symbolic part, Your Honor, that this right of the defendant to insist that the witnesses against them be brought into their presence has strong symbolic
Mr. Mercier, I understand what Justice Sandifer is saying, but also, isn't there some idea that it's a lot harder to lie to people face to face and tell untruths about them while they're there and able to confront you directly. I mean, was that part of the reason for the protection or not?
Certainly, that's part of it. It's this whole bundle of intangible things that when people are in a room together, it is different than when they are on video. That when you can feel someone looking at you, when you make eye contact, it's physical. I'm not one that likes eye contact very much, and it's an effort for me to do it. A screen is different for me. I mean, to tell a bit of a story, there was an oral argument maybe 4 or 5 years ago where I was appearing before Your Honors in Bozeman. And Justice McKinnon, you asked me a question, and I seized up. I could not think. All I could feel was everyone watching me and this little dialogue in my head saying, it's been 6 seconds since you've said anything. It's been 7 seconds. And eventually, Justice Shea, you leaned over Justice McKinnon and you said, I think you got it. And we all kind of laughed, right? And then Justice McKinnon, you graciously reminded me what I was supposed to be talking about, and we went on. Now, did that make me more or less effective? I don't know. It probably wasn't good that I forgot what I was talking about. But on the other hand, we shared this human moment of humor. So I don't know whether it's better or worse, but it is different. And it is for the defendant to decide what the right is worth to him. And that right to insist, to have the state bring its people in front of him and prove its case. In Craig, they talked about the strong symbolic purpose served by requiring the testimony in the defendant's presence. We, the people, expect that before our government puts one of us in a cell for the rest of his life, the government must bring its witnesses into that person's presence and prove its case there in front of him.
But counsel,
That's what a trial is.
the precise language out of Craig is, as it relates to the essence of the test for what Craig viewed as permissible virtual cross-examination is, quote, the reliability of the testimony is otherwise ensured, end quote. So again, you still haven't answered my question. How is the reliability of the testimony not as equally assured by virtual cross-examination as live cross-examination in the courtroom?
So in Craig, reliability is one of 2 prongs, right? One prong is it reliable? Is the video working? Is he testifying under oath? Is he subject to cross-examination? Even if you have that reliability prong, you still must establish the necessity prong. It is a separate prong under Craig.
You're not answering my question about how is the reliability diminished or impaired here.
I guess my answer is 1, human interaction will always be different. And that difference is what the defendant has entitled to serve. The court in Crawford talked about, as to reliability, made the point that dispensing with confrontation because testimony is obviously reliable is akin to dispensing with a jury trial because the defendant is obviously guilty. The court held in Crawford that is simply not what the Sixth Amendment prescribes. I agree these are intangibles. I will never be able to tell you exactly how it will play out in any given trial, but that doesn't make it unreal. And it doesn't change that it's guaranteed in Craig.
So under the facts, though, here, are you contesting more the necessity prong or the reliability prong, or both of them together? I mean, it seems to me that your argument with regard to necessity is expense versus, $670 worth of expense versus putting someone in prison for life, that those, that's a significant difference, and you'd have to have some real necessity, and that might not meet it. Whereas reliability, I'm similar to Justice Sandifer. I mean, you haven't really contested the testimony wasn't reliable, or that the video was not functioning well, or he was getting help with his answers or something like that.
Right. I mean, the reliability prong of Craig, we did not challenge. The video cut out a couple times, and it wasn't perfect. But two-way video satisfies the reliability prong of Craig. Sure. But there's a second prong that always must be satisfied, which is necessity. And it was not satisfied, or they didn't even attempt to satisfy it.
Counsel, can
Yes.
you move on to the characterization of this witness as being foundational.
Right, and so that's the state's core argument, is that there is an exception to face-to-face confrontation for foundational witnesses. They provide no citation for that, and none exists. If you look at both the article, there's a Sixth Amendment in Article 2, Section 24, provides the right to confront the witnesses against him. Not the non-foundational witnesses, not the non-reliable witnesses, not the accusatory witnesses, the witnesses, all of them. In Melendez-Diaz, the United States Supreme Court rejected this exact same foundational non-accusatory witness exception to confrontation. The court there applied the confrontation clause to a forensic drug analyst, and the court explained this is because the text of the amendment, the Sixth Amendment, contemplates two classes of witnesses, those against the defendant and those in his favor. The state must call the former, the defendant may call the latter. The court explained, contrary to respondent's assertion, there is not a third category of witnesses, somehow helpful to the prosecution, but immune from confrontation. Similarly in Crawford, the court again has started. Just because the state thinks he's reliable or thinks he's foundational, doesn't mean there's no confrontation. The same way, just because the state thinks my guy's guilty and should have pled out, but he still has a right to a jury trial. There's just zero textual, zero precedential support for this foundational witness exception. It does not exist.
Counsel, this court is, oh, excuse me, Mike, Chief.
No, you go ahead. Go ahead.
I wanted to challenge you about the Crawford reference and the challenge to the state's rationale on, or distinction regarding foundational witnesses. We have case law to that effect, and it's predicated on the distinction and focus in Crawford on what is and what is not testimonial evidence in the constitutional sense. And the essence of those cases, in our case that was post-Crawford, is that you don't have that problem with these foundation witnesses within the framework of how the U.S. Supreme Court has defined testimonial evidence under Crawford. So I don't understand why that's not a valid distinction, at least as far as it goes.
I disagree with that, Your Honor. First, this was testimonial because he was literally testifying at a trial, right? I mean, so to say it's not testimonial,
That's not the definition of testimonial in Crawford, just because somebody's in court under oath giving testimony.
I mean, I think Your Honor is. I think Crawford looks at the other thing. So later development cases of Crawford, you come down to this, our primary purpose. Was the primary purpose of this to preserve testimony for use at trial? Well, here the testimony is for trial. But even if it wasn't, even if this was his report, it would fail Crawford because this was submitted as part of the event. This was submitted months after Trevor had been charged. This was part of the prosecution. So exactly like Your Honors held the, Laird, the autopsy expert, making statements in the investigation of the case. This was part of the investigation of the case. It would fail, his report would fail Crawford because it is testimonial. On top of that, he is literally presenting testimony, which is what the Michigan Supreme Court said in its case from last June.
So counsel, you don't.
Counsel, can you hear me?
Yes,
This is Rice. I don't think anyone is envisioning that we would have trial by videos and everyone could appear by video. And this question may lead into your desire to talk about Dwayne. My question is, then what rule would you articulate that would would capture the constitutional requirements that courts could apply so that we don't have to have an appeal on every single one of these rulings about an out-of-state witness, but would give trial courts some degree of guidance on when it's permitted.
I want to feel like that's a little bit of a softball. To me, the U.S. Supreme Court has already laid it out. It's necessity under Craig, right? Which is a well-developed body of national case law that the U.S. Supreme, that our courts can look at. We adopted that. Your Honors adopted that and stopped. you apply Craig necessity under both the Montana and federal constitutions, and Craig has been working for decades. Dwayne, if I can get to Dwayne then, the district court allowed the video testimony here because the district court read in Dwayne's impossible or impracticable language an economic inconvenience exception. Such an economic inconvenience exception violates Craig. No other state high court, no federal circuit court has ever held that government expense justifies an exception to face-to-face confrontation. Dwayne, in that regard, is a unique outlier, if that's how it's interpreted. So we urge this court to overrule Dwayne explicitly, to return to the prior holding and stop, that Craig necessity is the test in Montana under both the Montana and federal constitutions. Doing so, reaffirming necessity as a test, avoids confusion, brings the state back into clear compliance with the Sixth Amendment, and again, gives our trial courts a well-developed body of case law as to what necessity is. I do want to say about Dwayne, though, before I get off it. So we urge the court to overrule it, but I want to make clear that even under Dwayne, the district court here erred. Because Special Agent Johnsrud's in-person testimony was not impossible or impracticable. He was a professional witness who the state was fully prepared to get there. There was nothing unanticipated about his testimony occurring at trial. In contrast to the private citizen in Dwayne, who had unexpectedly moved out of state prior to the 3 misdemeanor trials. So we urge this court to overrule Dwayne, but even under Dwayne, the district court erred. And again, in my mind, necessity provides a very well settled, fairly flexible, right? Courts across the nation, it originally was invoked to apply for trauma to child witnesses. And then courts have said, well, it covers physical inability of the witness to be there, health reasons. I mean, say COVID, right? I mean, if there's a finding, Judge Waters in Billings in June was asked to quash 2 subpoenas from out-of-state witnesses. She didn't. She did a Craig necessity analysis, looked at them. They had some health problems, but they were not significant. They didn't have to fly. She felt they could drive there in isolation to the courtroom, and that would be safe, and she made that finding. And so she, under Craig, rejected the necessity there. But it's a well-developed body of law that courts have been applying across the country. And I think there's no reason it doesn't give the courts the flexibility they need where necessary. Not where convenient, not where just saving some money, but where truly necessary to have the trial occur.
So counsel, is there any, I know you've cited Melinda Diaz for the foundational slippery slope evaluation of a witness and that we stay away from that. But is that the only, have other courts factored into the necessity requirement what the witness is going to offer in terms of testimony?
No court has ever done that to my knowledge. And think about how in addition to being unconstitutional, because the right is to testimony, to confront the witnesses at trial, whoever they are, whatever they say. The only exception is if they literally can't testify at trial because they will be traumatized or because they're in a country that we can't cross borders with or whatever. But think about also how unworkable it would be pre-trial. The judge would have to make a decision as to whether the witness is going to say things that cross the line. And then if during trial the defense asks a cross-examination question that wasn't unexpected, you stop the whole trial and then you fly the witness there? It just would be utterly unworkable to have anything depend upon the content of what's being said. The line has always been, is it necessary? Are they testifying at trial? Yes or no? Is it necessary for them to not, for some reason? That's always been the line. And so the state has the suggestion, that with technological improvements, there's a trend towards treating video as the equivalent of face-to-face. But if you look at the cases, Carter, which is the Ninth Circuit's case, applying Craig to reject the use of two-way video testimony for an adult witness, it's less than 2 years old. And then if anything, the movement's in the opposite direction, with the Michigan Supreme Court in June of this year unanimously imposing a categorical proffer ban against the use of two-way video testimony for adult witnesses. So there is no national trend away from the right to physical face-to-face confrontation. I'll reserve the balance.
Counsel, I have a question.
Yes, absolutely.
So the face-to-face language in Montana's Constitution, and we've always said we don't walk lockstep with the federal Constitution. Is there any significance to that language and providing enhanced protections?
So our argument, just to be clear, was Craig, we prevail. In Stock, the court adopted Craig, so there's nothing different about that. I certainly think you could craft an argument that when our founders chose to insert that specific language, it had meaning. And you could perhaps craft an argument that that presented a categorical ban, that it always must be face-to-face.
You're not presenting that here.
That is not our, because to be very blunt, the violation of Craig was so clear here that I didn't go looking to pick a fight. And because this court in Stock said Craig's necessity standard works and that it means the same thing. Additionally, if the federal court ever had interpreted, if the federal court in Craig had said, no, video's an absolute substitute, you don't need to have any exception at all, well then I would think under the Montana Constitution our call out to face-to-face would have to have some meaning and say, no, we require face-to-face. So I think the argument exists. I didn't choose to make it here because I think Craig is just so clear because this court adopted Craig and Stock. Yeah. Thank you, Your Honor.
Mr. Doherty.
Thank you, Your Honor.
Good morning, and may it please the court. My name is Michael Doherty, and I'll be representing the state in this matter. I'd first like to start by addressing Mr. Mercier's arguments regarding his confrontation rights. Then I'd like to conclude the argument by addressing the issue of harmless error. Trevor Mercier was not denied his rights under the United States and Montana constitutions when the district court allowed a foundational witness to testify by two-way video. Although the United States Supreme Court and this court have found that there's a preference for live face-to-face testimony, neither court has held that this right is absolute. Neither has held that the right of confrontation guarantees in-person questioning. The question, I think, before the court is what test to apply in this situation. In this case, where two-way video technology implicates a defendant's confrontation rights. Mr. Mercier cites State v. Stock and City of Missoula versus Duane as applying the Craig test, Maryland versus Craig. This court did not directly address in City of Duane the public policy prong, but I think the cases can be harmonized. If this court intends to apply the Craig test to the facts of the situation, the facts meet that test. I'd like to discuss the Craig test and how all the facts of this case meet that. But first I want to discuss the Craig test generally. The Craig test is a flexible test. It allows for the facts and circumstances of the specific case to enter into the analysis. I disagree with Appellant's argument that this is a very strict test. It's a flexible test that can be modified to allow or interpreted to allow for various situations.
Well, do you agree that the test is a two-pronged test under Craig, that you look to necessity and reliability?
Your Honor, in State v. Stock, this court did indeed apply the Craig public policy prong to that question of whether Montana statutory scheme dealing with child abuse victims and two-way technology is constitutional. So I think State v. Stock did apply that test, and this court would be, if to follow its precedent in Stock, would be required to apply it.
Counsel, Stock is very different from the facts here, and Craig is very different. Both of those cases involve young child sex abuse victims. Here we don't have that. There was a public policy reason for allowing those children or providing some sort of protection to those children.
Yes, Your Honor. So,
I'm sorry, go ahead.
I was just going to say, Your Honor, this court is free to disregard the public policy prong if it's inclined to do so. In the Second Circuit, in the case the Gigante decision, the Second Circuit does not apply the Craig test. It applies its own test based on Rule 15 of the Federal Rules of Criminal Procedure. So clarify my answer, this court in Stock applied the test to that situation. It would not be required to do so here, but if it does, the test meets Stock. It meets the Craig test.
So when you say Craig is flexible, though, are you saying that we're flexible in deciding what our public policy is? I mean, is that what you're getting at?
Yeah, yes, Your Honor, that's part of it. The flexibility comes into what is the public policy at issue, and then the other part of this test is what's necessary to further that public policy. And I think under the facts and circumstances of the case, what's necessary to further that is flexible.
So what was the public policy here?
And here, Your Honor, the public policy was derived from an implicit finding in Duane, which discussed impracticability due to expense and distance. I think that finding that supports the public policy of the efficient administration of justice.
But counsel, if you're talking about public policy and being flexible, if you're going to consider the factors that go into that in terms of what's required here, there's a huge difference between 3 misdemeanors and a homicide, and requiring somebody, a lay witness who has moved out of state, who isn't particularly motivated to fly back to testify for an afternoon, versus somebody who is a professional witness who is, and there's no, at least as I can tell, there's no argument from the state that it was cost prohibitive. It was just that this was a witness that it was going to be a $600 plane ticket. I mean, when you're talking about flexibility, don't you have to consider what kind of case you're talking about? I mean, we did in Stock, it was a child sex abuse case, and there were factors that tended towards saying, okay, we're going to allow it because of the trauma of the child. In Duane, there was also the fact that we're talking about misdemeanors. Here it was a homicide, and we're talking about a plane ticket.
And Your Honor, I think the cost of getting Agent Johnsrud to testify is just one of the factors the district court considered. The district court also considered the distance. Agent Johnsrud was in Greeley, Colorado. I'm not disputing that he is a government agent, but he would still have to require over 1,000 miles to come to trial.
But he wasn't walking.
No, you're not.
We're talking about an afternoon flight.
And I think that's where the impracticability comes into this, because it was complicated travel arrangements, which is just one factor that the court considered here. It's not the linchpin. The state's not arguing that expense will always outweigh a defendant's interest in two-way testimony. Here, under the factors of this case, and under the specific facts and circumstances of this case, the district court determined that two-way testimony was appropriate. There's always a preference for live face-to-face testimony, but that preference can give way to the facts of the case. The court here also relied on Duane for impracticability, but that was just one part. The court also discussed the nature of Agent Johnsrud's testimony. He was to be a foundational witness. And again, the state's not taking the position that every foundational witness can be exempt from in-person live testimony. It was this combination of factors in this case. He was a foundational witness. It wouldn't require extensive cross-examination, did not require extensive cross-examination at trial. It appeared to be he testified for less than 15 minutes. This was just, the foundation aspect was just one part of this. And I think the district court, relying on this court's authority, or this court's decision in Duane, found that taking those factors, weighing them against the defendant's preference for in-person testimony, the two-way testimony here outweighed that preference.
Counsel, wasn't this detective the one that basically did the analysis of the phone?
So he was an agent with Homeland Security. The phone was recovered on scene by a criminal investigator that was then sent to a agent in Kalispell to download and retrieve the information on that phone. The agent in Kalispell had difficulty doing that, so he essentially sent it to the higher up, an individual with more skill in extracting this information. Agent John Root was that agent. Agent John Root didn't testify to the facts. He was not going to provide any testimony as to the substance of the data that was extracted. He merely described his methods and the procedure for extracting that data, and then how he combined it into a report and sent it off to the investigator of the case. Actually, it was the county attorney to review. And so I think here it's important because of the foundational aspect of this. He was just merely describing how he retrieved the data. He wasn't a victim or a fact witness.
But that data was significant in terms of the state's case.
And it was introduced by another agent who was live and in person and available for in-person cross-examination.
That testified as to the report.
Exactly. The substance of the report and ultimately the two photos at issue in this case.
Which was the smoking gun in the case.
I disagree with that, Your Honor, but I'll address that in my harmless error analysis.
Mr. Doherty, before you move on, I'd like to get back to your statement. Have you clarified? You said this court would be free to disregard the public policy prong. I guess I'm not sure how we are free to disregard what the U.S. Supreme Court said in Craig, which is that a defendant's right to face-to-face confrontation cannot be abridged unless the denial is necessary to further an important public policy, and only where the reliability of the testimony is otherwise assured. So how can we disregard this necessary to further an important public policy prong?
Your Honor, the Gigante Court, the Second Circuit, found that it did not need to apply Craig because it distinguished Craig, the facts of Craig, which was one-way video testimony. In this case, it's two-way video technology. That being said, Your Honor, if the court is inclined to apply Craig, the facts of this case meet it.
And just to get back to that, I mean, in Crawford, the court said dispensing with confrontation because testimony is obviously reliable is akin to dispensing with jury trial because a defendant is obviously guilty. This is not what the Sixth Amendment prescribes. So that seems pretty plain.
2 points to that, Your Honor. Crawford dealt with out-of-court testimony, I believe, and this was in-court testimony. So I think it's distinguishable on that point. I've already forgot my second point, so I'll just move on.
Well, you were starting to say, before I interrupted you, you were starting to say why it meets the Craig test.
Yes, Your Honor. It necessarily furthers the important public policy of the efficient administration of justice. This policy has been recognized by numerous courts. It's important, specifically in a state like Montana, a rural state, where distances are measured in hours, not miles. I think the two-way technology is also meets the reliability prong. As the court has already discussed, the two-way technology, the modern day two-way technology, meets all the hallmarks of reliability. And these hallmarks are the most important part of the confrontation clause, which is to assure the reliability of the testimony by subjecting it to rigorous
But the defense isn't. The defense isn't contesting the reliability.
Yes, Your Honor. I think my point is not necessarily the reliability prong, but the central concern of the confrontation is assuring the reliability of testimony through cross-examination. The public policy prong discussed in Craig, although important, is not the crucial aspect of the hallmarks of confrontation. This case, all the hallmarks of confrontation were met. Agent Johnsrud testified under oath. He was available for cross-examination. There was no evidence that his demeanor could not be observed by the jury, and his questioning was done in real time, albeit not in person. This meets all the hallmarks of reliability.
But counsel, there is there is a distinction, as Mr. Mercier alluded to, between sitting here, as I just said somewhat flippantly, drawing on Mr. Mercier's example, when you're actually in the room and having to look at the 12 faces or looking at you, as opposed to you're seeing one face and it's just the prosecutor and then possibly the defense attorney, or however it's conducted. I mean, there is something to be said for being physically present and what that entails and what that implies and the gravity of the situation, as opposed to sitting in the comfort of your own home and testifying via video. Wouldn't you agree?
Your Honor, the state's not disputing the role that face-to-face testimony has in confrontation and cross-examination. However, the state's argument is that you know, je ne sais quoi, the part of face-to-face testimony that's important is a preference that can be, under the facts and circumstances of the case, be overruled by a district court. And then that's what occurred in this case, Your Honor. Right? So the state's not disputing that, or not taking the position that two-way video technology is exactly on par, and that routine trials by video should be occurring. The state's merely arguing that the Supreme Court it's necessary to craft a test where the district court can weigh the factors of the circumstances of the case to determine if, under the facts and circumstances of that case, two-way video testimony is not appropriate.
Would one of the factors to I'm sorry, go ahead.
I just wanted to ask you if you agree that what we're talking about here is testimonial evidence in this case.
Your Honor, I would agree it's testimonial evidence.
Would one of the factors when you're talking about kind of looking at the whole panoply of issues to consider be essentially a prejudice prong? Then, I mean, in this case, we're talking about a foundational witness as opposed to, and there doesn't seem to be a real challenge to the credibility of the witness, to the claim, to the extent that the defendant is claiming there was prejudice. It's that the evidence for which the foundation was laid ended up being harmful. But if he had gotten on the plane, the evidence would have been admitted just the same. Is that one of the considerations, I guess? Yes,
Your Honor. I think that's part of the analysis that goes into this. And I think that goes with the district court's finding that because he was a foundational witness, that wouldn't require excessive cross-examination. So there was less of an opportunity for the defendant to be prejudiced by that. I would like to address harmless error unless the court has any other questions about public policy. Again, I think in this instance, under the Duane test, which was that a two-way video testimony can be utilized while weighing considerations of distance and expense, and if distance and expense weigh into that it would be impracticable for the witness. I think this case meets that test. There was not only great distance, out-of-state witness, there was considerations of expense, but there was also the foundational testimony aspect of this. Those facts and circumstances go into the analysis and seek to necessarily further the public interest of the efficient administration of justice by reducing the burden on witnesses to travel and efficient utilizations of a county's resources, especially a rural county, a smaller county, like the county in question in this case.
So, Mr. Dougherty, the states, you mentioned, I think it was Minnesota, a state that we could just go ahead and say two-way video, Zoom, anytime there's an ability to have that conversation, that examination, that it meets the Confrontation Clause requirements.
You know, the state's not asking for a black letter rule or a one-size-fits-all situation. I think it has to be a factor in facts and circumstance analysis that occurs.
And we're controlled by Craig.
I think the court's decision in Stock would suggest that. However, this court can clarify that.
And you want us to clarify, Craig, by making an exception under the necessity prong that includes efficient administration of justice, an exception to a fundamental constitutional right.
I think that what the state's asking for is in certain situations, it would be necessary, the district court can find that it's necessary to further a public policy by allowing two-way video testimony. It doesn't compromise the rights of the defendant. In this case, it did not.
And
Well, counsel, excuse me,
go ahead.
Justice. No, you finish.
I forgot. Go ahead.
Sorry. Well, counsel, you've taken the position that the state is not suggesting that we should have commonplace two-way video trials or witnesses. Then in your recitation of the justifications for why this was okay here, you referenced that practicality was at least part of the formula, but there is no practicality here other than expense. So how do we draw the line between saying that expense is a sufficient, government expense is a sufficient justification and convenience, frankly, to allow this, but at the same time say that we're not going to have commonplace video conferencing trials? How do we police that line if we agree with you?
Your Honor, I think that's up for the district court.
And how does the district court decide that? On what criteria?
The facts and circumstances of the case. The important, the specific circumstances that are going into the state's request to allow two-way video testimony, and whether under the facts of that case, the two-way testimony would be appropriate.
And what were they here other than expense and convenience?
Your Honor, the district court never found that convenience as a reason.
I'm asking you. Well, you've read the record. What were the factors here other than expense of travel and convenience that should justify this?
It was expense is one part of it. It was also the distance that the witness would have to travel, but it was also, I think, importantly, his role as a non-fact witness and not a victim, merely providing foundational testimony.
So, counsel, if we apply those considerations, doesn't that have a different effect in rural areas than a place that's urban in Montana? I mean, you're talking about rural counties where there's less money, less income, and a lot more distance to travel to get there. So aren't we applying, wouldn't your efficient administration of justice consideration work differently in a rural area than in an urban area?
I think it's one consideration, and I don't want to make generalizations that all rural counties have lesser budgets, but it is a consideration and it's a factor the court can consider. But again, the state's not arguing for a hardline rule here.
Well, but doesn't that become somewhat unwieldy if we're talking about that, and that's going to be a consideration on a case-by-case basis, that we're going to require the prosecution to submit the county's budget to find out whether it's impractical for them as opposed to a different county?
I think I'm getting you straight here. This is not what occurred here, and I just want to focus on the situation of this case. If a court would consider that in a hypothetical situation of the budget of the court, I mean, that would be another issue. I think my point was that was more going to the reliability prong, that this testimony, this manner of testimony it meets the hallmarks of confrontation. Quickly, I'd like to address harmless error. If the court determines that allowing Agent Johnsrud to testify by two-way video was error, this error was harmless beyond a reasonable doubt. Importantly, there was never a question who killed Sheena Devine. At trial, Mr. Mercier conceded during his opening statements that he killed Sheena. He admitted to applying a sleeper hold on her neck until she lost consciousness. However, he claimed that this death was accidental and asked the jury to return a verdict of negligent homicide. Mr. Mercier's argument seems to suggest that these photos, the introduction of the photos at trial, seem to contradict or impeach his statement to police that he was in her apartment her duplex for a short period of time between the hours of 10 and 11. However, there's no reasonable possibility that the cell phone photos contributed to the defendant's conviction because of higher quality evidence introduced by the state that contradicted this version of events and proved that Mr. Mercier purposely or knowingly killed Sheena. This cumulative evidence, of course, includes Mr. Martel's statement. Mr. Martel's statement was he witnessed Mr. Mercier in the kitchen of Sheena's duplex sometime after midnight. This was higher quality evidence than the photos. The photos never directly placed Mr. Mercier in the apartment. It was an inference that the jury could rely on that Mr. Mercier was in the apartment. However, Mr. Martel's testimony was of much higher quality. He directly placed Mr. Mercier in the apartment. Contrary to Appellant's argument, Mr. Martel was never impeached. His testimony was consistent, clear, and uncontradicted. He had a clear line of sight of the window. He did not mistake Mr. Mercier. He had met him on numerous occasions, including when Mr. Mercier was violently assaulting Sheena in the months prior to this. He knew Mr. Mercier. It was no mistaking who he was because he was surprised that Mr. Mercier was still in the kitchen after the partner family assault. He assumed that they would no longer be together, and he was surprised by that. In addition to the evidence, Mr. Martel's evidence contradicting Mr. Mercier's version of events, the physical evidence of the case contradicted Mr. Mercier's version of events. Mr. Mercier gave a statement to police where he stated that he was in an altercation with Sheena. It was brief, lasted less than a minute, and then he carried her inside. He did not testify, or excuse me, he did not give a statement that he viciously beat her, but that's what the evidence showed. Multiple witnesses, in fact, I think every witness that viewed Sheena's body testified about the conspicuous bruises around her neck, around her face, and all over her body. She had a black eye, she had bruising all over her neck. The medical examiner in the case testified that there was a laceration or abrasion under her chin associated with strangulation. Sheena also had a fractured sternum. And the medical examiner testified that this was not the type of injury caused by someone giving CPR. It was caused by blunt force trauma. So Mr. Mercier's version of events that he told law enforcement that this altercation was brief and he merely applied a sleeper hold to her was not consistent with the physical evidence. The medical examiner, Dr. Obrest, also testified that Sheena's death did not suggest an accidental death. Dr. Obrest provided compelling testimony regarding the time it takes to die by strangulation. Mr. Mercier told law enforcement that he only applied the sleeper hold for 15 to 30 seconds. Dr. Obrest testified that it would take upwards to 3 to 5 minutes of constant pressure to cause death by strangulation. So Mr. Mercier's statement to law enforcement that it was a brief sleeper hold for 15 to 30 seconds is just not accurate with the medical evidence. I also want to mention I mentioned the prior partner family member assault. This also went to intent and lack of accident.
Counsel, can you address, if we were to find a violation of the right of confrontation, how that works into the harm? I mean, all of this evidence, you're describing impeachment evidence of Mercier's statements. How is that going to fit into the analysis? What do we do if we find a constitutional violation?
Your Honor, I think that if the court finds a constitutional violation, it's necessary then to determine if the evidence in question went to an element of the offense. I think Mr. Mercier's argument that this is impeachment evidence went to the intent element. It undercut his argument that he did not hold the requisite intent to commit deliberate homicide. He claimed that his intent was merely negligent. And so this evidence undercutting his version of events, undercutting his defense, goes to the element of intent. So I think the court would then need to, under this analysis, determine if there was cumulative evidence of a higher quality that established the elements of deliberate homicide. And the evidence I've been discussing goes to that, goes to the elements of intent and the elements of deliberate homicide. I also want to mention that the photos, they had a dual purpose. I mentioned that they also went to his intent. In closing statements, the state discussed the photos as primarily going to the other charge, tampering with evidence. But the state acknowledges that there is some value to the deliberate homicide. However, as I mentioned, there's much higher quality evidence that establishes beyond a reasonable doubt that that evidence didn't contribute to, the photo evidence didn't contribute to his conviction.
Well, counsel, how is this not this not prejudicial error, at least as to the tampering conviction?
If the court determines that, Your Honor, I understand. But the important argument made by Mr. Mercier was that this evidence went to the deliberate homicide charge. And the state's taking a position that this evidence went to intent, and then also had the more primary purpose of the tampering of evidence charge, that it placed Mr. Mercier next to the phone in the kitchen when he claimed that he never touched the phone, never tampered with it, and was never in the kitchen. So again, the primary focus by the state was the tampering evidence charge, but it also goes to intent. In closing, the court should affirm Mr. Mercier's convictions for tampering with evidence and for deliberate homicide of Sheen and Devine. Thank you, Your Honor.
Mr. Murphy.
Thank you. So I'd like to start with the state. There has to be a test. The district court needs a test to apply. Craig says under the Sixth Amendment that test is necessity. This court can't change that. The Sixth Amendment, the test is necessity. When the state was talking, counsel for the state would say a bunch of things and then add up to say that, so it's not appropriate to give face-to-face confrontation here. But again, the test under Craig is necessity. And yes, in Craig, the court used the word preference, but it was not like a flavor of ice cream preference. It's, this is the right. It is not absolute, but you can deny it only where you make a case-specific finding of necessity. Additionally, the burden is on the state. The right exists. It's not for us to justify that we should be allowed face-to-face confrontation. It's not for us to come in and say, we're an innocent enough defendant that we are entitled to a trial. We're entitled to a trial. We're entitled to have the state prove its case under the Constitution. If they want the exception, the burden is entirely upon them. The state talked about Gigante. Gigante is a 1999 case from the Second Circuit in which the court there said that they were not going to apply the Craig test to a video. Instead, they applied exceptional circumstances and an unavailable witness. So just as a first matter, if this court were to adopt a Gigante, this would clearly fail it here. There were no exceptional circumstances, and the witness was not unavailable. He was fully prepared to testify. But Gigante has been rejected by every circuit court that has considered it since then. And even more importantly, the federal rules, the proposed amendments to the Federal Rules of Criminal Procedure in 2002 were explicitly based upon Gigante. That's what the Rules Committee cited, and that's what the U.S. Supreme Court rejected. And then Justice Scalia wrote and explained that the difference between one-way and two-way video doesn't matter because the point is the defendant is still not in the presence of the witness. When looking for what necessity means, there's this developed body of case law that the district court can look to. What are other examples? Well, in Yates, the 11th Circuit said that it was not necessary to use two-way video for two witnesses who were in Australia because the government could fly the entire defense team and defendant to Australia and do the deposition there. No court has ever said that economic expense is a justification to deny face-to-face confrontation. It has never happened, except perhaps this court in Duane. And the Michigan Supreme Court, the June case, has a footnote in there in which they say Duane is the unique case that they could find anywhere in the country that has ever even suggested that economic inconvenience would be necessary.
You're going to get to harmless error.
I'm going to get to harmless error. So first off, the state's right, this is not a whodunit. It was undisputed that Trevor caused the death. The question the jury had to decide was what was in his mind. Did he have a conscious disregard of the risk of death, or did he purposely knowingly cause death? So a very hard question about what was in his mind. The jury was instructed they could look at the surrounding circumstances. Trevor's defense was that his initial statement to the police was candid and described negligence. To rebut that, the state presented a witness, Mr. Martell, who contradicted Trevor's account by purporting to place Trevor in Sheena's apartment at midnight. But Mr. Martell's account, his testimony, his credibility as a witness were heavily impeached by the defense. In particular, on cross-examination, they documented that his ability to recollect other times that night were off by more than 2 hours. The prosecutor candidly acknowledged below that she made the final decision to introduce these photos based upon Mr. Martell's testimony. That is, after Martell got cut up on cross-examination, the state needed this electronic photo data to salvage Mr. Martell's testimony, to salvage that aspect of its case, and that's exactly what the photos did. So having made that choice that they needed this evidence, they can't come in now and say it had no effect. Additionally, electronic time data is always going to be qualitatively more persuasive than human recollection of time. But that's especially true here where the witness was impeached. The state used the photos in its final closing examination. The defense had to spend 3 pages of their closing argument trying to deal with these photos. They tried, at the end of trial, to explain that these photos might have come from one of the children in the house. The state slammed the door on that hard, pointing out that the girl was not tall enough to take the photo. The state chose to put this evidence in. It needed it. And it cannot now say that there is no possibility it made a difference when its very purpose. I guess so. In the briefs we cite Reichman, which is another case where there was an impeached witness, and so the state presents electronic data whose very purpose is to confirm the testimony of that witness. That's its prejudicial impact.
Counsel,
It gave the jury another reason to believe the witness.
how could the defense have undermined this disputed evidence if this witness would have been in the courtroom on this record?
So first off, we'll never know the intangible effects, but we never know. Questions were not asked. Is the phone's time accurate? Is the phone in the right time zone? Was it in the right time zone when this happened, even if it's in the right time zone now?
How come those questions couldn't have been asked over the, why couldn't they have been asked over the video?
At the time, defense counsel didn't realize what was occurring. They thought that the phone data was going to be used for text messages, and they were making hearsay objections. It was only after the phone call was hung up that the defense realized what the purpose of this witness was. Now, maybe, we will never know, but maybe if they had been there in present, they would have gotten some physical tell from him and thought to ask some of those questions. We will never know. But that doesn't make it real. It doesn't take it out of the Constitution. It is not on our burden to justify that we should have confrontation.
We're talking about harmless error though right now. We're talking about harmless error right now. And so I'm trying to understand how you want us to reason that this was not harmless error, if it wasn't.
And again, I also went a little bit down the wrong track. Coy makes clear that in this area of face-to-face confrontation, the harmless error, the court cannot speculate, for good or bad, what the witness would have said differently if they'd been in person. Coy makes absolutely explicit that all you can do is excise the witness and evaluate the harmless error based upon what remains. And what remains is an impeached Mr. Martell that the state felt they needed to rehabilitate with this evidence, and that's what it did. It was the smoking gun at the end of the case, and that's why it's prejudicial.
Counsel, can you speak just really briefly? I know you had talked about it initially, but I don't have really clear notes on it in terms of, I know your preference would be that we reverse Dwayne, we overrule Dwayne, but you also said that this can be squared with Dwayne, and I'm trying to see how you do that.
I'm saying the district court erred even under Dwayne because this witness was not impossible or impracticable to secure. Any more than that his testimony was not necessary. They literally said they could get him there. They bought the plane ticket. So how could that be impossible or impractical under Dwayne? There are other alternatives. So we urge overrule, but if you wanted to make the narrowest ruling, you could reverse under Dwayne and put the constitutional question aside for another day. That would leave these conflicting standards out there, cause confusion. It would deprive Montana's trial courts of the necessity test. You could alternatively, if you're crafting narrower approaches, you could read Dwayne as a purely state constitutional decision. I mean, Dwayne literally only interprets Article 2, Section 24. It never purports to interpret the Sixth Amendment. It never purports to apply the Craig test. So you could say, well, that's what the Montana Constitution means, and the federal Constitution means something else, which again, doesn't seem like a good idea to have two conflicting tests, but you could do that.
Well, counsel, you couldn't do that.
Well,
Because we have to at least apply the minimum standard of Craig.
our courts do, but our Constitution could not even have a confrontation clause. Now, you would still have the right to confrontation under the federal Constitution. So at a very technical level, the Montana Constitution could be interpreted differently, but you would always have to give the federal floor in trial.
Right.
Again, not a good idea in my opinion. And finally, you could just simply read impracticable. You could just say by judicial fiat, that means necessity. And that would square them. But then why have two words if you're just going to do necessity? Why not just place necessity back front and center as this well-usable test? Thank you, Your Honor.
Thank you to both counsel. This concludes the argument portion of this case. The court will now take it under advisement and we will issue an opinion in due course. Thank you very much.